I would like to start, Ms. McLellan, by thanking you for the three issues that you went through. They are three of the issues that we hear a lot about all the time, and I attended your earlier briefing made available for senators several months ago and heard about that, and I was impressed that these issues were explored in depth by the committee, and that for the most part the government actually heeded, and as a minister I would have done that too, because in an issue like this it gives you much more ability to not deflect, but to say that there are others involved in looking at this over a longer period of time. I want to ask you about one issue that you didn't talk about, and that's 12 to 18-year-olds. If I may, the Criminal Lawyers Association was here, and the Canadian Bar Association. They both raised issues, the equity issue from youth and how they're treated under the Youth Justice Act, and the treatment of adults here. And they propose that if a person under the age of 18 ends up going through the ticketing process, et cetera, but then there can be all sorts of conditions put on them, and if they violate any of those conditions, they could be brought back before the justice system and could end up facing sanctions that are much stiffer than if an adult was in the same situation. I'm probably not explaining that, but as a former justice, explaining it well, but as former justice minister, you will know what the issue is there. Can you help me with your interpretation of whether we have either a constitutional equity charter issue or just a disproportionate effect on young people? Does it vary from other bills? That's what I'd like to explore.
Quite honestly, I think the reality is that there will not be a disproportionate effect on the 12 to 18-year-old. Going back to the task force report, what we make very plain in the report is that we do not believe the criminal law is the appropriate vehicle to deal with young people who are found with small amounts for personal possession or small amounts for personal use, and that's why and that's why you see in the legislation the 5-gram issue, and what then that spoke to was the fact that we don't want anyone under 18 using, right? That's clear, and the report is clear. But we do know that some in that age cohort will use. We don't think it's appropriate they're caught up in the criminal justice system. We left it open to the provinces and the territories to fill the gap, if you like. That was quite deliberate, right? It wasn't an accident. And they have all done so. To the best of my knowledge, they have all done so.
So you don't see that there is an equity issue? I'm sorry to cut you off,
I don't think so, okay. Because they will be dealt with practically in most cases, the policeman, the beat cop will take whatever the kid has and say, you know what, go home, this is a warning, right? They might give the kid a ticket and there's a fine. And yes, that involves a certain issue, but that is much, much better than having that young person tied up in the criminal justice system, either the Youth Criminal Justice Act, well, it would be the Youth Criminal Justice Act.
I think that we've heard a lot about not wanting to criminalize young people, and I agree with that. And I was just more interested in this technical legal. And,
I think it's an issue that I would say if it were ever, I honestly do not see that arising practically.
Okay. I want to move on to another issue again. This is about the technical writing of the law and the interaction between the federal government and the provincial government. And you just indicated that on this, it was purposefully written in a cooperative federalism approach to allow for the provinces to do that. On the issue of home grow, it's quite different. The provinces of Quebec and Manitoba have taken a different position and have said no plants. And the federal government has said, well, we won't take you to court, but if an individual citizen takes you to court, which that will happen, we will defend the federal record, i.e. this is a law of general application, it's a law of federal paramountcy. I don't understand the reason for that. I don't know why a patchwork approach to the number of plants is so harmful. I don't know why we can't leave that up to the provinces, who are also going to have to deal with the issue of multi-unit buildings and other sorts of things. Do you have a reason why it would be wrong for us to pursue clarifying that the provinces do have the ability, like in the treatment of 12 to 18-year-olds. In this treatment, they do have the ability to set a limit lower than 4 plants, including 0 plants if they wish.
Well, I'm not going to get into a constitutional discussion here. That will be up to, I guess, the Attorneys General of Quebec and Canada. What I will say is that after hearing all the evidence, we believed that cannabis is going to be legal. The plant is going to be legal. And we allow people, for example, to make their own wine. They're allowed to grow tobacco, right? And if you are actually legalizing, does it make sense to have an absolute prohibition on the growing of what is now a legal plant, a plant that leads to a legal substance? We took on board the experiences of states that have legalized, and they all, but the state of Washington, have home grow or home cultivation with a certain number of plants. In fact, some of those states, except Oregon, have a higher number of home grow plants than we have. We thought, on the principle of caution and public health and safety, better out of the box to keep this restrained for plants. We actually don't think many people are going to grow their own plants. Very few people make their own wine.
Come to my part of the province. Honestly, I'm serious.
No, but
It's
that's because there is not readily available quality assured retail, right? And there used to be lots of stills right after prohibition of alcohol. We went back and looked.
Come to my part of the province, there still are.
Yeah, well, as the stores actually and the market regularized, very few people make their own wine or make their own booze anymore. And
Okay, my question really was, can't we let the provinces
well,
decide the number? Yeah.
Senator Malte.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Minister, as my colleague mentioned, Quebec will be stuck in between a rock and a hard place. Bill C-157 is going to be tabled this week, and it will prohibit the growing of 4 plants. The federal legislation will say this is allowed. So in Quebec, as of the 1st of July, will we see the Sûreté du Québec policeman seizing 4 plants in an apartment, and then we'll see the RCMP come back returning the 4 plants? What will happen to citizens in Quebec?
I am not the Minister of Justice. I used to be, but I'm not anymore. And I'm not part of the Government of Canada. We were an independent body set up. We heard the evidence around whether people should be allowed to grow a certain number of plants in their homes, this now legal plant. And we took it all on board and we decided, yes, caution spoke to the fact that 4 plants were reasonable. Let's not be too paternalistic around this now legal plant. But if Quebec chooses 0 home grow, and the federal government has allowed 4 plants, I think the federal Minister of Justice has said that she will not challenge that in court, but some member of civil society might, and then the matter will be joined and it will be resolved ultimately probably by the Supreme Court of Canada. That is all I can say because I am not a member of the Government of Canada.
Merci.